Feeling underdressed, though.
Yeah.
So willing.
Yeah, they match. See, look, I went into that version today.
That sounds funeral. Yes.
My lords, I wonder if I might make on behalf of our personal request before we start.
Yes, you may. Yes.
Thank you. Act according to Nugee. May we extend to the gowns as well?
Why not?
Thank you. Collectively, it had the temperature of the court on the question. My lords, as your lordships are aware, this is an appeal from an order of His Honour Judge Saffman in Leeds. In this matter, I appear on behalf of the appellant insurers, the learned friend Ms. Taylor. Mr. Halpin, Queen's Counsel, appears for the Bishop. Mr. Learmont, Queen's Counsel, for the Charities. And Mr. Gazeman, Queen's Counsel, for the Solicitors Regulation Authority. Sorry, it was Kendrick. Sorry. Do beg your pardon. Right place, wrong man. My lords, your lordships have seen the skeleton arguments, including the skeleton lodged most recently on behalf of the Regulation Authority, I hope.
Yes, yes. Thank you.
The point is a relatively short one, in fact.
Yes.
But it is of some significance. It is an area where there has not previously been a direct authority. And I don't think it's contentious to say that is probably because such disputes as have occurred have been dealt with by way of arbitration between the solicitors and their insurers over the years. But it remains of significance, and as your lordships are aware, this all arises out of the conduct of Mrs. Linda Box, formerly the senior partner of Dixon, Coles and Gill, and still, I think, recently released from a long sentence of imprisonment. She was also the registrar of the diocese and latterly a chancellor of another diocese before her long-term dishonesty was discovered by one of the two innocent partners in the practice, which led to the investigation, her imprisonment, the intervention in the practice, and finally these proceedings. The matter which came before His Honour Judge Saffman was twofold. Firstly, an application for summary judgment and an account against the innocent partners, and thus the insurers. And secondly, an application for a declaration under the policy that the insurers were not entitled to aggregate the claims presently made with those that they had previously paid up to the limit of indemnity. Regrettably, the practice only had the minimum mandatory level of indemnity of £2 million.
We don't have much idea, do we? Or when I say much idea, we have not much information about the nature of the other claims which have been settled, or whether are there any outstanding?
Well, the regulation authority has told us they understand there to be claims outstanding.
Right.
Realistically, we are now more than, I think, 6 years after the intervention into the practice. So, whilst I cannot discount the possibility that other claimants might come forward, they might have difficulties in...
So far as the papers before us are concerned, we only know the basis, is this right, of the claims made by the Schofield respondents and by the Bishop.
And the Bishop, yes. And you get, should you wish to know more, you can get a little more from the reports of the forensic accountants who are embarked upon a preliminary exercise, particularly to look at the question of teaming and lading,
yes,
which is in the supplemental bundle. As to scale, you also get a slight additional picture from the criminal sentencing statement of Mr. Justice Blake on the occasion of Mrs. Box's imprisonment. At that stage, the matter was being dealt with as involving at least £4 million. The Bishop's claim started at a sum which was very significant and would suggest that the total sums were greater than that. But I don't think there's very much more that I can put before your lordships today that shed greater light upon the potential total ambit, not least because, given the period of time over which Mrs. Box's conduct took place and the way in which it took place, I'm not sure that anybody could ever get to the bottom of how much money she defrauded people of, not least because some, at least, of the victims were estates. And in those circumstances, it is often very difficult to dig down into what was properly there. I'm not sure I can shed a great deal more light upon that.
You said that the policy monies have been paid up to the limit of indemnity.
Yes.
Is that in relation to other claims that aren't
Yes.
before us?
Yes, other claims.
But we don't know anything about them. So how can we decide whether they form the same claim as these claims? I mean, is it really just accepted that
at this stage, because this was, as it were, a preliminary hearing before judgment had been entered, so
Yes.
far as the charities were concerned, it was very difficult to set out, by way of statement of case, what had happened in other claims, not least because they are confidential as between the claimants and the practice. And although there isn't an appeal from His Honour Judge Saffman's direction or order that this could be heard as a summary judgment application, one of the practical difficulties that flows from a departure of what was perceived to be the usual course under the 1930 Act is that the lifting of the veil between the claimant and the practice has not been entirely completed.
Yes, and I think there's a reference in the judgment to it being the practice for insurers just to pay the first claims that appear.
Of course, exactly. I mean, generally speaking, and certainly I think the experience of those of us in the field over the years is that the insurers feel obliged, as a claim is calculated or agreed or a judgment is entered, to discharge them in order, because to do otherwise would be favouring one against another.
But there's no pari passu sharing.
Even
if you know that the total number of claims is going to exceed the policy limit.
Absolutely right.
Yeah.
And therefore, in some of these cases, there can be a somewhat unseemly rush to judgment. Strangely enough, in these cases, nobody seems to have been in any particular hurry, oddly enough, but there we are. So, my Lord, the matter has proceeded, and in our submission, insofar as it's possible to deal with this matter on the basis of a preliminary hearing, it has to proceed on the basis that the pleaded case, that is to say, that the claims all fell within the overarching conduct of Mrs. Box in diverting money from the client accounts to her own pocket, is the way in which this preliminary hearing has to take place.
Thank you.
My Lords, by way of introduction, or rather adding very slightly to the background, it may be convenient just to take your Lordships very quickly to the sentencing comments in the supplementary bundle. My Lord, the indictment appears at flag 12, starting at page 75. The first count is one of theft over a period between April 2003 and December 2014 of 63,000 belonging to the Bishop of Wakefield, and then counts 2 to 10 are all counts, to 11 are all counts of fraud over different but extended periods of time, distinguished by the use to which the money was put. So count 2 is paying her tax bill, count 3 is numerous payments to her credit card with accounts of over £3 billion, count 4, payments to her bank account, count 5 to her husband, count 6 to an organisation called H2 Communications, which was a front for her receipts, and so on and so forth. And then that is followed by 2 counts of forgery, which were forgeries undertaken in order to get access to the money. Well, that's followed by the sentencing remarks of Mr. Justice Blake.
Did she plead guilty to all 10 counts?
She did, my Lord. And they start at page 80. He records that so far as the criminal proceedings were concerned, the majority of the offending took place between 2010 and 2015. But it had started as long ago as February 2002. He recorded that the total value of dishonesty on the 12 counts was just over £4 million. He recorded her admissions. The extent of her use of the funds is set out at page 81, about a third of the way down the page. The scale of your credit card spending revealed in this investigation on jewellery, £800,000 over 6 years on vintage wines, regular stays at the most luxury hotels in London and elsewhere, as well as redeeming mortgages on properties you'd acquired, paying your income tax, paying school fees, buying expensive gifts for your family that were all out of proportion to your legitimate income. And he then goes through the process prior to making a sentence of 7 years imprisonment. For the sake of completeness, that's then followed by the compensation order, which was made by Her Honour Judge Belcher in Crown Court of Leeds. That was subject to an appeal and was eventually raised to just under £2.5 million. That also is not distributed pari passu, but by reference to the losers identified in the indictment. It was the subject of considerable difficulty, which gave rise to a further allegation against the insurers, because the way in which the Crown Prosecution Authority dealt with that matter meant that a number of those who thought that they might be receiving a payment didn't. And there was some question, which I don't know whether it's yet fully resolved, of whether or not some of the recipients had already been paid by the insurers. But that's a difficulty happily the Lordships are not troubled by today.
So this is an indication of the scale of the numbers affected by her activities.
My Lord, it's an indication,
Yeah.
but
No more.
I don't think anybody
Yeah.
is suggesting that the indictment covered the full extent
Yeah.
of her
No, nor the compensation.
Nor the compensation.
Look, this is on page 81, Justice Blake's sentencing remarks. In the middle of the page, there's a paragraph beginning amongst the many victims of the wrongdoing, the beneficiaries and executors of the many client accounts held deceased.
Yes.
So that gives a flavour of what quite a lot of it relates to.
Yes, certainly. I don't think there's any dispute that the losers were the charities and estates. Well, also, unless I can assist you with the background any further, I'm grateful to my friend for that intervention. I'll go straight to the policy, if I may.
Yes.
I have set out in our skeleton at page 28 of the bundle what we consider to be the relevant clauses. This is a claims-made policy, and therefore insurers holding the policy at the particular year of the claim have the misfortune to be confronted with claims in respect of the previous extended period of years. Clause 1.7 of the policy, claim is defined, means a demand for or an assertion of a right to civil compensation or civil damages, or an intimation of an intention to seek such compensation or damages, and then has an additional provision for these purposes, an obligation on an insured firm or any insured to remedy a breach of the solicitor's accounts rules shall be treated as a claim, and the obligation to remedy such breach shall be treated as a civil liability. I'll come back to that, if I may, at the very end of my submissions when I deal with the alternative argument relating to one claim. It's a deeming provision which, so far as the innocent partners are concerned, operates when they discover the loss, because they are then immediately responsible for making good the loss.
So the general definition is a claim made against the practice. And this, as you say, is a sort of an extension of that, or a deeming provision.
It's an extension that deals with the discovery of a deficiency in the client account.
And that's explained in the skeletons, isn't it? The purpose behind that.
No, yes.
Yes.
It's fair to say some measure of disagreement between the parties as to how that purpose should be addressed. And then there's the dishonesty exclusion, which is why Mrs. Box obviously has no benefit of an indemnity at all. In the light of my learned friend, Mr. Kendrick's submissions, I do draw your attention to the exception at the end of paragraph 4.8, except that this insurance nonetheless covers each other insured who did not commit or condone the dishonesty of the fraudulent act or omission. And I'll come back to that if I may later. The liability of insurers shall in no circumstances exceed the limit of indemnity. That's 6.1b. And then 6.1c, for the purposes of the limit of indemnity, all claims against one or more insured arising from one act or omission, b, one series of related acts or omissions, and C and D, which are only of peripheral importance, but learned friends place some weight upon them for comparison purposes, will be regarded as one claim. And then there's a conventional excess provision. What
was the excess in this case?
My lords, I knew your lordship would ask me that, and I'll have to come back to it because I've entirely forgotten to track it down. But it's fair to say that the partners are the subject of insolvency.
My lord, page 187. It's £5,000.
Okay. Yes, and capped at 15,000 in the aggregate. In fact, as you see in Judge Saffman's judgment, he referred to the minimum terms and conditions throughout. They don't vary in any respect at all in this case, so there is no difficulty with that for any purpose whatsoever.
You said the innocent partners were insolvent. The firm itself is in an insolvency process.
Exactly.
And the individual partners, have they been made individually insolvent?
When I last knew, they hadn't. There was a partnership, partnership insolvency arrangement, but not, I think, an individual one. But they are
as far as we're aware.
Yes, I think that's common ground between us. So, my lords, the first ground of appeal is that the learned judge below fell into error in concluding that the persistent dishonest removal of funds did not permit the aggregation of these claims. Your lordships will, I'm sure, have had an opportunity to read the judgment of Honourable Judge Saffman. It's a long judgment. The greatest part of it is a loyal and comprehensive recital of the arguments tendered by my learned friends and myself to his lordship. The reasoning whereby he reaches a conclusion is actually relatively shortly expressed. And perhaps I can take your lordships immediately to that.
Maybe that's not unexpected, because otherwise you might just be going round and round in circles saying the same thing in different ways.
But maybe I'm right.
I wasn't sure whether you were.
Whether you were
implying a criticism or were you just making an observation.
No, I simply making an observation.
Right.
Many years I shared a room with Harvey McGregor, who tended to the very firm view that the length of a judgment was not, in any sense, indicative necessarily of its quality. But, my lords, the conclusions really start on page 99 of the full bundle, paragraph 261. So bringing the threads together, were the acts of theft one series of related acts? I remind myself that in answering this question, it's not enough that HDI has a case that satisfies the test necessarily to avoid summary judgment on the authority of Appellant, to which I referred in paragraph 24 above. This question has to be decided on balance. I have concluded that the thefts from Mr. Halpin's clients and from Mr. Learmonth's do not have a sufficient interconnection or unifying factor with any other claims to bring them within the aggregating clause, even if there was wholesale teaming and lading. I accept that the language of this aggregation clause, when coupled with the glossary definition of claim, may not equate claim with cause of action, and that the scope for aggregation by virtue of the minimum terms and conditions is wider than it was in Lloyd's TSB. But notwithstanding that, I do not think that it permits aggregation of the Bishop's claim and the claims of LDBF on the one hand with those of the Schofield claimants on the other, or the claims of either party with the claims of other claimants whose claims have already been satisfied. In my view, a unifying factor which is sufficient to unite these acts of thefts for aggregation purposes is simply not present in this case. By reference to the comments of Lord Hobhouse, which I recount at paragraph 225 above, what caused the financial losses to the two sets of claimants in this case were separate thefts from each of them. And then what we submit is where the learned judge goes wrong. It was not Mrs. Box's dishonesty which was the proximate cause of their loss. I agree with what Mr. Halpin says in this connection, which I recount at paragraph 200 above. Dishonesty is not an act, it is a state of mind. What caused these claimants' losses were the individual thefts from them. True it is that these were motivated by dishonesty, but it is the acts that matter, not the motivation for the acts. These acts resulted in different losses to different clients. There cannot, in my view, be said to be a single loss, because I'm satisfied that the acts of theft were not related on a proper construction of clause 2.5a2. Furthermore, I simply do not see that there is a sufficient interconnection between the acts, to use the words of Lord Toulson in AIG, to which I refer in paragraph 236 above. I do not see that the thefts from the Bishop and from LDBF fits together with the thefts from the Schofield claimants, saying that they were all committed by the same person and perhaps concealed by the same process, factors which in my judgment are not enough. My Lord, he then goes on to recount the observations of Lord Toulson and concludes that the thefts were separate and unconnected. And although he says he's conscious at the end of that paragraph that Lord Toulson was considering matters and transactions and their relationship, but as I mentioned in paragraph 236 above, I have no doubt that what he says there is transferable to the question of the relationship between different acts and omissions. I remind myself of the test that Mr. Learmonth promulgates, which I set out at paragraph 243 above, and that was a test which the learned friend contended was of assistance, whether or not the case could be pleaded without reference to the connecting feature. And he says it seems to me that it has much to commend it. It's consistent with the decision in AIG to the effect that the claims of the Turkish and the Moroccan investors did not lend themselves to aggregation, but the claims of the investors in each cohort would. It also fits comfortably with the decision in Lloyd's TSB. He goes on to say that the connection is a fact-sensitive matter. I recognise the strength in Mr. Poole's submissions that there is a necessity to find facts before consideration could be given to the relationship between the acts. And he then recites part of the judgment of Lord Justice Lewis in Easy Air, and then goes on to say, effectively, given that he had found the conclusion, it was right to make the declaration. He deals with teaming and lading. Briefly, paragraph 271. It's simply unrealistic to conclude that there's any basis on which evidence can produce a sufficiently unifying connection between the thefts from the Bishop and LDBF on the one hand and the Schofield claimants on the other, or with the thefts from other clients whose claims have already been satisfied. If, as I have concluded, wholesale teaming and lading doesn't do it, it's unrealistic to think that any other evidence might. I also observed that AIG was a preliminary issue. Well, Lords, those are the paragraphs that deal with his reasoning. And his reasoning is essentially, I don't think that there is a sufficient connection. In our submission, he fell into error because he allowed himself to conclude that dishonesty was not an act and therefore did not come into consideration. The test that has to be applied is whether or not the claims arise from a series of related acts or omissions. And the dishonesty in our submission goes to the relationship between the acts. Perhaps if one considered it in this way, had this been two solicitors rather than one, acting together to remove these monies over the years, one would have had no hesitation in concluding that there was one conspiracy. And that is also reflected by the counts in the indictment. Again, they're dealing with fraud, but they were dealing with multiple occasions on which the fraud was undertaken over an extended period of years. And in our submission, when one looks at the words, that is to say, one series of related acts or omissions, and applying an objective, common sense approach to those words, to say that there is no relationship between the occasions of theft undertaken by Mrs. Box in order to discharge her credit card debts, or pay her husband, or buy her vintage wines. It is to fly in the face of logic. The dishonesty was not of itself an act or an omission, but it was at the heart of the relationship between the acts or omissions. This is necessarily a question of judgment, and it is why these cases can be fact sensitive, and often are. And I have no hesitation in accepting that if Mrs. Box had been guilty of a theft in 2002 and a separate theft from a different loser in 2015 and had kept herself entirely clear of all misconduct thereafter, I would have a very uphill struggle seeking to demonstrate to any tribunal that those two separate occasions should be the conclusion that they were related. However, that is not what we were dealing with and are dealing with in this case. We are dealing with an extended course of conduct on multiple occasions over many years. There isn't a clean break at any stage. It is not in our submission a case where it is possible sensibly to say Mrs. Box walked out of the office on a given Wednesday afternoon, concluding that's the end of my dishonesty. But when she came in the next morning and there was a chunk of money in the client account that she fancied the look of, that was a new process which started on Thursday morning and was quite separate from the process which she had in her own mind brought to an end on Wednesday afternoon. There is in any event no suggestion of that. But even if that were to be the case, that would fly in the face of a conclusion as to whether or not the conduct of Wednesday and the conduct of Thursday was related. It was related because it was all underpinned by a dishonest approach to the conduct of the client account of the practice. That is the nub of our submission, and that in our submission is also consistent with the authorities, which, contrary to the submissions of my learned friends, do not lead to a conclusion which in any way forces the court to depart from what we submit. It is a sensible and logical approach to the interpretation of this sub-clause. And my lords, the two central cases are the Lloyd's TSB decision and AIG. It is striking that over the 20 plus years in which the commercial market has provided cover to the profession under the minimum terms and conditions, cover having commenced, I think, on the 1st of October 2000, when the previous Solicitors' Indemnity Fund ceased to proffer cover. The particular circumstances before the court today have not had to be considered by a court because there have been numerous occasions when there have been occasions not dissimilar to that of Mrs. Box. It's a matter of record that, in fact, on the very first day of the commercial market, a gentleman who had merged a number of practices and had consolidated their client accounts walked away with the totality of the client account. Mr. Dixon was his name. But in our submission, the authorities do not in any way constrain the court from the approach which we contend for, which we set out in front of your lordships and set out before His Honour Judge Saffman. Lords, can I take you to the Lloyds?
So just summary, the pivotal part of your submission is that the claims come within the provision because of the dishonesty
Yes.
of the
This
solicitor.
was a course of consistent dishonest conduct
Yep.
by Mrs. Box.
Thank you.
It was one person acting in a given way, albeit with a number of different losers, albeit that the losers were all through the offices, principally through the client account. So if we can look at the Lloyd's TSB decision, and in our submission it's necessary to have quite close regard to the two decisions in order to see what they do and don't decide, and whether they in any way constrain the courts to the conclusions for which my learned friends contend. I don't know how far I need to take your lordships to the facts of Lloyd's TSB. It all arose out of pension mis-selling, and in particular the movement of individual pension holders from in-house schemes to external schemes.
Employee benefit schemes or whatever they were.
Exactly.
Yep.
My Lord, the problem for Lloyd's TSB was that it had a number of constituent parts which had been involved in such matters. It did have a reinsurance provision, but the question was whether these were individual claims or whether the claims all could be aggregated for the purposes desired by the insured, because the sum total of the claims was £125 million, but the largest single claim amounted to no more than £35,000, well within the individual limit of cover. So the fight was effectively against the primary cover, which was a captive, and the reinsurers contended that none of the claims failed to be aggregated, and the deductible of £1 million had never been reached in any of the individual claims. At first instance and in the Court of Appeal, it was concluded that the claims did aggregate, and therefore that the reinsurers were liable for a sum in excess of £1 million.
I don't think we've got those. Were there those decisions on the basis that the lack of training was the
essentially so.
Was the equivalent of your dishonesty? Was it? I mean,
up to a point.
Up to a point, yeah.
Yes, effectively so. Different reasoning at first instance before Mr. Justice Morbick, and then in the Court of Appeal, which I'll come to in a moment.
Okay.
The reasoning of the two courts below is set out in some detail in the judgment of Lord Hoffman.
Thank you.
Part of the other recurring difficulty of this particular authority is that there are two leading judgments from Lord Hoffman and Lord Hobhouse, with which, both of which, the other members of the House of Lords agree. And their reasoning is different, and therefore encapsulating the decision is not entirely straightforward, but we would submit that on this occasion the headnote does accurately reflect the sum total of the decision. If I can take you first to Lord Hoffman, the first important feature we would submit in considering this case is that the insuring clause was very different from that which you find in the minimum terms and conditions, which I've set out. Because whereas that was an all-encompassing insuring clause, in this particular case, the insuring clause was linked to the cause of action. And so if one turns to paragraph 10 of the judgment on page 82 of the bundle, the risk of liability for mis-selling under the Financial Services Act fell within the insuring clause of section 3 of the policy. This policy provides an indemnity for any third-party claim which meets the following requirements, and it must be for compensationary damages first made within the policy period, and 3G be for financial loss caused by a breach on the part of the assured or an officer or employee of the assured of the provisions of the Financial Services Act 1986, in respect of which civil liability arises on the part of the assured. And then he goes on to recite the schedule of underlying deductibles. And for section 3, there was to be a deductible of £1 million each and every claim. The same is repeated in item 7 of the schedule. The effect of the deductible was stated in paragraph 2 of the conditions. The underwriter shall be liable only for that part of each and every third-party claim during the policy period which exceeds the deductible. The deductible shall apply to each and every third-party claim and shall be the subject to no aggregate limitation. And he continues at paragraph 12, so far so bad for the TSB company's point of view, no single claim came anywhere near exceeding the £1 million deductible. The TSB companies rely and have so far succeeded on the aggregation clause which follows the clauses I've already quoted. And the aggregation clause, he then sets out, if a series of third-party claims shall result from any single act or omission, brackets, or related series of acts or omissions, close brackets, then irrespective of the total number of claims, all such third-party claims shall be considered to be a single third-party claim for the purposes of the application of the deductible. And as we'll see in a few moments, Lord Hoffman places very considerable weight upon the existence of those brackets. In order to decide the effect of the aggregation clause, the following issue was directed, and he then deals with the judgment of Mr. Justice Moore-Bick, who said that the purpose of the clause was to enable two or more separate losses covered by the policy to be treated as a single loss for a deductible or other purposes when they're linked by a unifying factor of some kind. That seems to me to be a fair description. And that is, in our submission, absolutely right. I mean, almost a statement of the obvious. It begs the question is, what's the unifying factor has to be in a particular policy? The unifying factor, Lord Hoffman continues, is often a common origin in some act or event specified by the clause, but much will turn upon the precise nature of the act or event, which for the purposes of aggregation, the clause treats as a unifying factor. The more general the description of that act or event, the wider the scope of the clause. For example, in municipal mutual and sea insurance, unifying clause was expressed in very general terms, all occurrences of a series consequent on or attributable to one source or original cause. And he goes on to say, as long as you could find any act, event, or state of affairs, that would effectively do. And then at the top of page 49, he goes on to look at AXA Reinsurance and Field, where Lord Bustill contrasted arising from an originating cause, which had been used in Cox and Bankside, with the words arising out of one event, and in a classic phrase often used in these cases, reflects upon the very stark difference between looking for a cause, particularly an originating cause, and an event, which is far more restrictive. So Lord Hoffman continues, the choice of language by which the parties designate the unifying factor in an aggregation clause is thus of critical importance and can be expected to be the subject of careful negotiation. In paragraph 18, in the present case, the unifying factor is, as in the example so far given, a common cause, but that cause must be a single act or omission, or by an extension in the parentheses, related series of acts or omissions. So the question turns upon the meaning of an act or omission or related series of acts or omissions. He then deals with the judgment of Mr. Justice Morbick, as he then was, and states that in his view, it included any acts or omissions of the kinds described in the insuring clause, and that included the breaches of duty in respect of training schemes. The Court of Appeal at paragraph 20 didn't agree with this. They drew attention to clause 2G of the endorsement, which defines the term act or omission. For present purposes, the relevant parts of the definition is that the words are deemed to mean a breach of the provision of the Loutra rules as described in the insuring clause. So, pausing there, what that meant was you could only use acts or omissions which were specifically those which were giving rise to the claim. So it mirrored the cause of action relied upon. The relevant part of the insuring clause is paragraph 3G, which insures against a breach in respect of which civil liability arises on the part of the assured. The Court of Appeal said that an act or omission must therefore be something which constitutes the investor's cause of action. It cannot mean an act or omission which is causally more remote. So he said it was therefore necessary to examine the nature of the cause of action. It's a contravention of Rule 4.4a to ensure that the company representatives comply with the Code of Conduct. And then goes on to consider that. And in paragraph 22, he says it follows that the absence of a training or monitoring system, even though an independent breach of the rules, was legally irrelevant to the civil liability of the TSB companies. And Lords, we'll come back to this, but essentially that was because each and every one of the claims arose out of an alleged failure to provide the best advice to the recipient on the part of the agent. Even without, he continues, any such system, they couldn't have been liable unless their representatives actually contravened the code. Likewise, any such contravention wouldn't have given rise to liability whether they had a training or monitoring system or not. It cannot therefore have been an act or omission from which liability resulted. Thus far, I respectfully agree with the Court of Appeal. The language of the aggregation clause, read with the definition of act or omission, shows that the insurers were not willing to accept as a unifying factor a common cause more remote than the act or omission which actually constituted the cause of action. I pause there. That limitation simply does not arise in the present case. An act or omission could qualify as a unifying factor in respect of more than one loss only if it gave rise to civil liability in respect of both losses. In the present case, the act or omission which gave rise to the civil liability in respect of each claim, failure to give best advice to that investor, was different from the acts or omissions giving rise to the other claims. The Court of Appeal then turned to the words in parenthesis, or related series of acts or omissions, and in construing these words, they produced exactly the result which they had rejected in their construction of the primary words, single act or omission. They said that acts or omissions could be related and form a series if they had a single underlying cause or common origin, or if they were the same omission which had occurred on more than one occasion. Justice Long. The appeal was therefore dismissed. And this result seems to me paradoxical. It means that the parties started by choosing a very narrow unifying factor, not any underlying cause, not any event, or even any act or omission, but only and specifically an act or omission which gives rise to the civil liability in question. Having chosen this as the opening, and one must assume primary concept to act as a unifying factor, they have then, by a parenthesis, produced a clause in which the unifying factor is as broad as one could possibly wish. It is sufficient that all the claims have a common underlying cause, or on the view of Lord Justice Longmore, the breaches of duty the same, which I take to be sufficiently similar. In my opinion, this construction is allowing the tail to wag the dog. I do not think that it is reasonable to understand the parties as having intended the parenthesis to stand the rest of the clause on its head. When one speaks of events being related or forming a series, the nature of the unifying factor or factors which makes them related or a series must be expressed or implied by the sentence in which the words are used. And I pause again, because my learned friends will seek to submit to your lordships that these statements by Lord
Sorry,
Hoffman,
hold on a second. So I just got a message that it's proposed that some engineers come in to install coolers. Which oh, there they are. Sorry, yes. Presumably they're going to. Where are we? What do you think? You all right? It is quite hot. How long do you think they'll take? Shall we wait until they come? And then we can see if they're going to take only a few minutes, then we will rise. Okay?
my lord,
We can't take our gowns off.
I'm sorry, I beg your...
We can't take our gowns off.
No.
Anyway, yes.
My lord, I was on page 85, paragraph 20.
Sorry to interrupt.
No, not at all. When one speaks of events being related or forming a series, the nature of the unifying factor or factors which makes them related or a series must be expressed or implied by the sentence in which the words are used. And that emphasises that so far as Lord Hoffman was concerned, when he was looking at the passage in parentheses, it was in the context of the sentence as a whole.
Well, I mean, yes, but we have a sentence. So, I mean, you're at the moment just distinguishing our clause from this clause.
Absolutely right.
And at some point, you're going to go through this. What you say are the specific differences, which mean that what Lord Hoffman said don't apply to us.
Most importantly, and I can deal with that very briefly, in the clause with which your lordships are concerned, the sub-paragraphs separate out one claim or series of related.
Yes, I mean, it's A and B.
And they have equal importance. One is not subjugated or subordinate to the other, whereas Lord Hoffman's interpretation of his consolidated clause treated the passage in parentheses as only capable of being interpreted in such a way that it did not detract from the restrictive interpretation which arose on the primary clause because of the insuring clause.
Yes, I mean, it's the tail wags the dog.
But
If one looks at our clause, it's all claims.
It is all claims.
And they were dealing with claims.
They were, but they were dealing with claims that mirrored the causes of action.
Well, claims in our definition essentially mean, don't they, civil rights, causes of action. I mean, if you put it in legal terms. Claim means a demand for an assertion of a right to civil compensation or civil damages.
My lord, yes, but it wasn't tying it any more narrowly than that, whereas in the Lloyd's TSB case, it was the precise cause of action, the precise breach.
Well, I understand that because that's what was being insured.
Exactly.
So, I mean, but I'm not sure that affects the meaning of the clause, because all this is saying is a claim has to be based on a legal claim, which obviously constitutes a cause of action.
But, my lord, yes, the distinction is that in the Lloyd's TSB case, the insuring clause was very narrowly drawn by reference to the causes of action within the Financial Services Act.
Right.
And the aggregating provision mirrored that. So the aggregation had to mirror the cause of action. In the present case, the claim is much more broadly defined, and there isn't the, as it were, straitjacket mirroring provision.
Right. And the second element is the claims arising from, and I can't remember the precise wording in this provision, but do you say there's any difference result from? So do you say there's any difference between arising from and result from?
I don't think there is a significant
Right.
difference.
So
Perhaps going back to your Lordship's first point, can I also remind your Lordships that we submit that first mirror image point is precisely captured in the holding provision in the headnote.
Sorry. Oh, right. Okay. Where is that?
That's on page 79, my lord.
And then it's A and B rather than in parentheses.
My lord, exactly right. And so of equal standing, rather one subordinate to the other. And Lord Hoffman re-emphasises the subordination clause in his interpretation of paragraph 27 on page 86. In the present case, the only unifying factor which the clause itself provides for describing the acts or omissions in the parenthesis as related and a series is that they result in a series of third-party claims. In other words, the unifying element is a common causal relationship. But that common causal relationship is, so to speak, downstream of the acts and omissions within the parenthesis. They must have resulted in each of the claims. This obviously does not mean that it's enough that any one act should have resulted in one claim and another act in another claim. That provides no common causal relationship. It can only mean that the acts or events form a related series if they together resulted in each of the claims. In this way, the parenthesis plays a proper subordinate role of covering the case in which liability under each of the aggregated claims cannot be attributed to a single act of omission. So he is placing a very constrained interpretation on the words we submit, the relevant words in our policy, because that is required in order to interpret the entire sentence and ensuring that the parenthesis plays a proper aggregated a subordinate role. And but for that, we would submit the decision in the Court of Appeal would have been the correct decision. Because he then, in paragraph 28, then goes on to depart from the reasoning of the Court of Appeal, because it doesn't fall within the restrictive interpretation he has placed upon the operative clause in paragraph 27. And he re-emphasizes this at the very end of his judgment, having indicated that he would reach a different conclusion from that of, potentially, that of Lord Hofhouse on a hypothetical, by saying at H, I think that it's wrong to allow doubts about the possible practical application of the parenthesis, particularly when the clause may have to be applied in a wide variety of circumstances covered by the insuring clause of section 3 of the policy, to provide a construction which undermines the balance of the clause. Each of the claims didn't arise from a single act or omission, nor did each of them arise from a related series of acts or omissions. So again, he emphasizes that his interpretation of the related series of acts or omission flows from his necessarily restricted interpretation of the parenthesis because of the primacy of the principal provision.
Well, I'm not sure. I understand that he has said in 26 and 27 that the parenthesis plays a subordinate role. But when you come to right at the end of his judgment at 29, I'm not sure he's there pinning it to the fact that the related series is in parentheses. What he's doing is he's construing the words shall result from. And he says the series of third-party claims, that's each claim, doesn't result from one act, nor does it result from a series of acts. They result from different acts. And that seems to me to be a decision on what the words result from mean.
Well, with respect, that immediately follows a passage in which he has repeated that doubts about practical application of the parenthesis shouldn't produce a construction which undermines the balance of the clause, which is going back to his previous point with our submission. And then he says each of the claims didn't arise from a single act or omission, nor did each of them arise from a related series of acts or omissions. That is in the light of the interpretation that he has placed upon it.
So I understand the point you make about the parenthesis. I'm not sure I understand the point about the unifying factor being a cause of action.
But my Lord, that is because of the unusual terminology. Perhaps if we look back to just wondering whether I can. So one starts with the insuring clause in paragraph 10.
Yes.
And there it is not only that a claim is made, it has to be a claim for financial loss caused by a breach of the provisions of the Financial Services Act.
Yes.
And then you go to paragraph 11, the schedule of underlying deductibles, and that is a deductible of £1 million for each and every claim. And then you get the aggregation clause, if a series of third-party claims shall result from any single act or omission, and that's the passage. His Lordship then goes on to emphasise at paragraph 20, when looking at the Court of Appeal, that they drew attention to clause 2G of the endorsement, which defines the term act or omission. For present purposes, the relevant part of the definition is that the words are deemed to mean a breach of the provision of the latter rules as described in the insuring clause. That's why the aggregation clause mirrors the insuring clause.
Why does that take in any way though? Because acts or omissions are always going to be, in this context, a breach of something.
But it has to be the breach. So in the present, in this case, the allegation, the breach which was relied upon, the cause of action was failure to give best advice, not failure to educate. And because the aggregation clause relied upon the same cause of action, you couldn't rely upon something which was extrinsic.
But are you drawing a distinction?
And that is
here,
quite different.
In our case.
Quite. There isn't that precise linkage between the claim and the conduct, the act or omission.
I've still not quite understood. I'm sorry, it's probably too hot and I'm being slow, but what I understood Lord Hoffman to be saying is the training is irrelevant. So Mr. Justice Moore-Bick's analysis is wrong. The Court of Appeal was quite right to reject that for the reason you've just given, that the training is not what causes the loss. What causes the loss is an individual salesman going to somebody's house who's an individual deferred pensioner of an employee benefit scheme and saying, sign here, you'll be better off with a defined contribution scheme which you can invest yourself. Each time someone does that, it's a separate breach. What I understand Lord Hoffman is to be saying is if you have pensioner A and salesman A, that's one act that's a breach. If you have salesman B, pensioner B, even if it's salesman A, even if he says exactly the same thing, exactly the same spiel, it's a different act, and you can't put those two acts together to form a series. The reason being that what the clause is looking at is, do pensioner A and pensioner B's claims arise from the series? No, they don't. Pensioner A claim arises from breach A, and pensioner B's claim arises from breach B. That's what he's saying, isn't it?
That's what he's saying in the context of that particular clause, my lord, yes.
But I don't see why that's not the same with our clause, where it doesn't use the words cause of action, but it uses the words act or omission. You have a claim arising from one act or omission, or one series of related acts or omissions.
Yes, well, Bob, that's the claim under the policy.
No, it's the claims against the insured. I'm looking at your skeleton on page 29, paragraph 7, where you set out the policy wording.
Well, both clauses use the term.
My lord, I beg your pardon, yes, that's quite right.
So all claims of capital C, leave aside your ground 2. On this ground 1, a claim is an individual client of the firm whose money has been stolen. And that is a demand for civil damages.
Yes, absolutely.
Now, when the bishop asserts a claim because of Mrs. Fox's thefts, if the bishop asserts a claim because of one theft, that comes within little a, that's one act.
Yes.
And I think it's not disputed, but if the bishop asserts a claim because she stole money from the bishop on 5 separate occasions, that's a series of related acts, because the bishop's claim arises from that series. But as I understand it, what the judge said is that the Schofield claimant's claim, though it also relies on her thefts, is not something which comes within little b, because you can't say the bishop's claim and the Schofield claimant's claim both arise from that series. They arise, bishop's claim arises from the thefts from the bishop's fund, and the Schofield claims arises from the thefts from the Schofield funds.
My lord, that is effectively what his lordship said below.
Yes.
But in our submission, that was wrong, because these were a series of thefts across the client account. Mrs. Box wasn't coming in today and saying, today I will continue my thefts from the bishop or from Schofield estate or indeed anybody else. She was coming and taking money from the client account. And so there was a series of thefts. The question is, were they related? And in our submission, they were related because they were all part of her one process of stripping out any available funds that she could get her hands on.
I don't think you're answering my lord's point as to the fact that different claimants, following Lord Hoffman's reasoning, their claim does not arise from the series of acts. Each of their claims arises from the act or series of acts which are directed against them, not from the other.
With respect, in the context of the claims in the TSB case, that was certainly the case, because the nub of the complaint was each individual claimant was entitled to whatever for him or her was the best advice. And so some people would have got the best advice inadvertently from the advisor, so it had nothing to do with education. There wasn't a common theme across the absence of best advice, apart from the lack of education, which wasn't material, because it wasn't part of the course of action. In the present case, you don't have that same constraint. Each of these cases involves a claim, that is to say, a demand for or an assertion of a right to compensation. Whether it's put as breach of trust, breach of fiduciary duty, money hadn't received, matters not. It's a claim for civil compensation. And so the question is, in respect of those claims, do they all arise from a series of related acts or omissions? The acts or omissions are the removal of the funds. The series is the process continued over a matter of years. The relationship is that it is all part of this stream of Mrs. Box's ongoing dishonest conduct.
I think that addresses the relationship point. But I think
It does.
I think what my Lord is putting to you is that there's a causation aspect.
Can I put it this way? The bishop is not concerned whether Mrs. Box stole the Schofield's funds or anybody else's funds. He's only concerned whether Mrs. Box stole his funds.
Quite.
So his claim arises out of the theft of his funds, and the Schofield claimant's claims arise out of the theft of their funds. As I understand what Lord Hoffman is saying, is it wouldn't fit within the clause in the TSB case because the two claims, the bishop's claim and the Schofield claim, don't arise from the same series of acts. And it's exactly the same here, that the bishop's claim doesn't arise from the theft of the Schofield claimant's funds or the theft of everybody's funds, the looting of the client account over a period. The bishop's claim, when it's pleaded, presumably is pleaded, arises from the theft of his funds. And his funds, that may be a series of thefts of his funds, but it's not a series for these purposes of thefts of other people's funds. The question isn't whether they're related, it just doesn't arise from those other thefts. And as I understand it, that's what Lord Hoffman is saying.
Well, with
the
respect,
claims have to arise from the same series. As my Lord said, it's a causation point, not a relationship point.
well, but my Lord, whether one looks at it as a causation or relationship point, in our submission, the series is the series of thefts from the client account. Right. It matters not whether it's today the bishop's funds, tomorrow the Schofield funds. The series is related to how this is being undertaken. Whether the money is taken first and allocated to the loser afterwards or vice versa matters not in our submission. What is in fact being stolen is the money sitting in the client account.
But as my lords have said, Lord Hoffman goes further than that, because what he says in paragraph 27 is that the acts or events only form a related series if they together resulted in each of the claims. Now, I understand you're saying that the clause now is different from the clause that he was considering. But if what he said does apply, that is the hurdle.
But Lord, exactly, and that's why it's so important to see in Lord Hoffman's judgment that he is placing a much more constrained interpretation upon the clause than the Court of Appeal, than this clause, because of its subordinate character as he sees it in the conjoined.
I see that, but it depends on what you're focusing on, and as my Lord has focused on, that you might focus on arising from.
Right.
And arising from means, according to Lord Hoffman, can only mean that the acts or events form a related series if they together resulted in each of the claims. That's his interpretation of it in respect of that, in that context.
Absolutely, but I accept that, and that's why it is so important when looking at the Lloyd's TSB decision to see the rather unusual.
But is it that you're saying the separation out of the clause into an A and B, with the addition obviously of C and D, is what's critical, or that it was in... So it's that which is critical, and that they're no longer in parentheses, and that changes the meaning of what is now B.
Absolutely. It changes it back to the meaning ascribed by this court in Lloyd's TSB, which did aggregate. And so far as Lord Hoffman was concerned, where this court went wrong there was in dealing with the two clauses, as it were, giving them, two parts of the clause, giving them equal status. Whereas in his interpretation, the clause in parenthesis had to be interpreted in such a way as to make it subordinate to the principle.
It's going to take 30 minutes to install.
I mean, your lordship's hands.
I didn't ask at the beginning whether, have you discussed actually how long your respective submissions are going to take?
We did have a discussion.
I should have asked.
I was allocated half a day, and my learned friends were going to. My learned friend, Mr. Kendrick, was only going to require a short period of time at the end.
Yes.
I was going to have a short period for reply. My learned friends, otherwise, Mr. Halpern and Mr. Limon.
Thought they would use a day?
They were going to use the best part of a day.
Really? Well, there's no point in there's no point in rising for half an hour and starting. So I think what do you want to do? Stop at 4? Yeah. Stop at 4. We'll stop at 4.
Oh, yes.
Thank you. Yes.
Conscious that I may be introducing myself more heat than light.
Right.
So, my lord, you're entirely right. That is what is so important in looking at Lloyd's TSB, that it does arise, at least so far as the judgment of Lord Hoffman is concerned, in these very peculiar circumstances. And they are circumstances which the redrafting of the clause in the minimum terms and conditions does away with by allocating each of the sub-paragraphs equal authority. Lord, that takes me on to the judgment of Lord Hobhouse. And again, he emphasises the importance of addressing aggregation clauses in an objective manner because they can operate either for the benefit of insured or insurer, depending upon the precise circumstances, as it is illustrated by the TSB decision.
Yes.
And then he goes on to deal with the code, and at paragraph 38, he recites that it's alleged and must for present purposes be assumed to be true, that at all material times the claimant concerned, its officers or employees, fail to consider, identify, and satisfy the requirements of best advice. And he deals with, here's a formulation of the issue at the foot of paragraph 39. Thus, the issues for determination are thus whether the mis-selling claims against the various claimants were a series of third-party claims which resulted from a single act or omission, and if not, whether they were a series of third-party claims which resulted from a related series of acts or omissions. And then he recites the Court of Appeal, and his discussion starts at paragraph 43. The scheme of the relevant parts of section 3 is firstly that it is a carefully drafted insurance clause which defines the cover given. It is of no avail to the assureds to present arguments which involve saying that the proximate cause or causes of the relevant third-party loss is something other than the insured cover there defined. This scheme is reinforced by the inclusion of the definition clause in effectively identical terms inserted for the purpose of defining the phrase act or omission as used in the aggregation clause. And with respect, that goes back to the point Lord Justice Phillips raised a few moments ago. So Lord Hobhouse is also placing particular weight upon that mirror image in both the insuring clause, which is of restricted ambit, and the aggregation clause. The result is that for present purposes, the third-party claim has to be one which is for financial loss caused by a breach on the part of the insured or an officer, employee of the insured, of the FSA or the Loutre rules. And the acts or omissions relied upon to trigger the aggregation clause must also to fit that description. And this was recognised by Lord Justice Potter. It has to be what proximately caused the loss suffered by the third party, and that was the act or omission of the consultant. So again, absolutely emphasising in this particular policy the identical nature of both the insuring clause and the aggregation clause. He then goes on to say, maybe that one should assume that the consultants were untrained. But he goes on at E, the essential factor in every case has to be that the breach, act or omission caused the third party financial loss. There was thus no single act or omission. Similarly, if there is to be a related series of acts or omissions, that description has to be true of the 20,000 claims, notwithstanding that every claim would have been different, every claimant would have been different, each financial loss would have been different, and the actual failure to give the best advice would have been on the part of many different employees of the relevant different insurers. So, pausing there, Lord Hobhouse is addressing whether there is the relationship. And it goes on. Similarly, if there's to be a related series, that description has to be true of the 20,000 claims, notwithstanding. It's of no assistance to the assurers to say that they were themselves each in breach of their obligations to ensure that best advice was given. The statutory requirement merely creates for the relevant assured an absolute liability. So that's in contradistinction to what we're dealing with here, where there is here one single individual conducting herself in this way, which gives rise to the series and to the relationship. He then goes on to look at the nature of the policy further at paragraph 44 and draws attention to the deductible and reaches the conclusion of the final sentence, the further fact that for these assured the deductible is set at £1 million shows that the primary intention is to confine the cover to large third-party claims. Again, I don't submit that makes any significant difference in this case, but it is important to bear in mind that is something also relied upon by Lord Hobhouse in interpreting the aggregation clause. The aggregation clause is applicable if there is a series of third-party claims which have resulted from either a single act or omission or have resulted from a related series of acts or omissions. The phrase series of third-party claims clearly carries with it the possibility that the claims may have been made by a number of third parties and each relate to the financial loss suffered by an individual third party, but do not as such import anything more. We accept that, but that is precisely what is happening here. The following phrase results from a single act or omission reinforces this. And then he's dealing with the single act or omission, requiring that to be the proximate cause. Paragraph 46, he goes on to the related series. And it's on this phrase the argument has mainly turned. On examination, he says, between C and D, this can be seen to raise the same fundamental difficulty as the argument on the primary phrase, single act or omission. The claims still have to result from something done or omitted as between the relevant consultant and the relevant third party. Absolutely. And these claims all turn upon something done by Mrs. Box and each of these claimants. The obligation of the relevant assured to insure doesn't take matters any further. And then he deals with the irrelevance of the failure to educate. And Goes on at paragraph 47. The assured's argument runs as follows. Each of the assureds was under a statutory obligation to take steps indicated in the Code of Conduct to guard against mis-selling. They didn't do so. As a result, consultants did not give best advice and mis-selling occurred. It follows that the various assureds did not ensure that it did not occur. The underlying cause of all the cases of mis-selling was the same, the failure to take the steps required by the Code to guard against mis-selling. The requisite steps and the failure to take them were either the same in every case or very similar. This argument therefore takes the inquiry back to an earlier stage. It does not look at what caused the financial loss to the third party, the subject of the third party claim, but at the underlying situation which gave rise to the conduct of the consultant vis-à-vis the third party. And again, in the present case, that distance is completely absent. Each of these claims arises out of the dishonest theft of Mrs. Box. And he goes on to say that effectively you could have had various other remote causes, such as not paying the people well enough, and so forth. He then considers the different phraseology of clauses. I don't propose to take your lordships through it, but it's essentially the dichotomy between cause and event, which are the two words which are most frequently found in such clauses. And he says, returning paragraph 51 to the aggregation clause in the present policy, there's no word of equivalent strength to those found in the AXA and municipal cases, attributable to a single source, originating cause. The argument of the assureds has to be built upon the inclusion of the phrase related series. But this doesn't have the same force or create such a strong and wide connecting factor. One is still left with the necessity to look at the acts and omissions of the individual consultants, which gave rise to the financial loss suffered by the third party, and whether they were a related series of acts or omissions. In my opinion, they were not. Whereas in the present case, each and every one of these cases arises out of the continuing course of dishonest conduct undertaken by Mrs. Box.
I don't know in the Lloyd's case how many salesmen were involved, but it wouldn't be difficult to suppose that one salesman dealt with more than one employee.
My lord, quite possibly. There were 22,000 claims.
Yes. So there's no suggestion that if there had been one or any one salesman's breaches could be aggregated in respect of different clients because it was the same salesman who was in breach of the obligations.
My lord, I'm sure that argument wasn't even addressed because we know that the largest single claim was £35,000 and the deductible limit was £1 million. And however assiduous a given salesman was.
You think he might not have reached $1 million?
And that would have assumed he had failed to give best advice as well.
Yes. Okay.
So, my lords, that wasn't addressed, I accept.
Yes.
But here, I think that does emphasise that it's not just the presence of the same salesman. It's the failure to give the individual recipients the best advice. There isn't that subtlety. What these individual claimants were entitled to receive from Mrs. Boggs was honesty. That is to say, they were entitled not to have their money stolen by her. There is no additional differential, regardless of how the case is formulated. And I know my learned friend Mr. Learmont says, well, we can't refer to the failure to account without mentioning Mrs. Box's theft. So he can, but that takes him no further at all, as is made clear long ago. For example, in the Low and Low decision, as between the insurer and the insured, the reality of what the insured was doing is the operative provision. So the fact that the claim is brought in failure to account doesn't prevent the insurer saying against Mrs. Box, this was a claim arising out of your fraud, And it doesn't prevent the insurers saying, as against the innocent partners, this is a claim which aggregates because it arises out of the course of conduct, the related series. So, my Lord, in our submission, whilst Lord Hobhouse takes a different route insofar as he does not drill down in the same way into the interpretation to be placed upon the aggregation clause, he concentrates on the congruence of the insuring clause and the aggregation clause in the round, and the fact that the matter relied upon for aggregation purposes is not permissible in those circumstances because it does not give rise to the claims in those cases. And I'm conscious that one of your Lordship's judicial assistants is present in court, and no doubt he can be asked to provide a ratio de sedente of the decision, which would be a task I wouldn't place upon anybody with any great enthusiasm, because there are two different approaches with which everybody agrees.
Does that not mean that, well, the entirety of the House, or at least four of them, subscribe to both reasons given? Both those given
that may be the way one has to approach it, but there is clearly a tension between the two.
Yes, they've not given identical reasons.
No, it's not quite Boyce and Chaplin, but it's a good, brave effort. But my lords, it matters not for my purpose. It matters not for my purposes, because on analysis, what your lordships see is a very different clause in its full effect, in very different circumstances, and lacking what is present here. That is to say, that the very acts or omissions relied upon as giving rise to aggregation are those which cause the loss. That is to say, the thefts. My lords,
is your next stop AIG?
my next stop is AIG.
Should we break then now? I'll find out about this court, so we may not be here tomorrow if there's an alternative.
Just before we break, can I ask you one question following up on something my lord said? Suppose there had been a single salesman who missold 30 policies, 30 pensions to pensioners, to members of occupational schemes. And the 30 were each worth 35,000, so you do just about get over the million. Would that be, in your submission, on this wording and on the analysis adopted by Lords Hoffman and Hobhouse, a single series of related?
Well, I think the only proper answer,
series.
I think the only proper answer that can be tendered to that question is that it might be, because it is fact specific. So if he is making exactly the same mistake in the context in which this liability arises, that might be. But even then, the difficulty is you've got two variables. You've not only got the salesman variable, you have the recipient entitled to the best advice variable.
But in the same way, every time Mrs. Box steals money, she steals it from somebody. She doesn't steal it from everybody. She steals it from a particular person, doesn't she?
Yeah, my lord, yes.
Well, why is that not the same as failing to give best advice to a particular member of a scheme?
Because there is no variable. Everybody is entitled to honest conduct. It's not a sliding scale. There's no judgment. It is exactly the same step which she is taking in every single defalcation. That is to say, the removal of client account money allocated to one of the clients. Turning the argument on its head, can it really be said that there is no relationship between the money she took in the morning and the money she took in the afternoon? And the answer to that question we submit is yes, she is the relationship. It is one person doing all of this.
Yes, I see. Thank you.
So 10:30 tomorrow. Thank you.